Good morning. Thank you. Please be seated. Morning, folks. We are here in our cause number CASA13 0263 involving the Peoria Unified School District as the petitioner versus the Honorable Crane McClellan in the Superior Court as the respondent and Timothy McKee as the real party in interest. This is the time set for oral argument on the school district's petition. We've conferenced this matter and we've decided, since we think we have some questions, we're going to give each side 25 minutes so we can chat. So as you come forward, that's what you will see. You're going to be arguing, Mr. March. If that, you will be able to manage your time for any rebuttal if you would like. But this is being audio taped, so we can listen to it if we need to. It's also, of course, also videotaping things. So if we ask you a question, don't anyone roll your eyes at us. We'll see it. I don't know how long we're keeping them or why we're doing it, but it's available. We have conferenced this matter. We've read the pleadings. I think we have an understanding of the issues. There's also, we will probably deal with it in due course, motion and response for judicial finding as well as an emergency motion now that, for a stay, now that Judge McClellan has issued the judgment, which went out on Friday. And so the 5 days starts ticking on yesterday. So with that in mind, Mr. Margie.
Thank you, Your Honor. Good morning. May it please the Court. My name is Kim DeMarchi, and I'm here this morning on behalf of the Peoria Unified School District, the petitioners in this matter. I did want to make sure the Court had seen the emergency motion. Please accept my apologies for filing a motion the afternoon before oral argument. It's just that 5-day reinstatement piece in the judgment that creates the timing issue. That's why we wanted to make sure to get it before the Court. I'm happy to talk about it, but I think I'm going to jump right into the merits of the special action itself. Court review of school board teacher disciplinary decisions is subject to a very specific statutory standard. Under ARS 15543B, the legislature has said the board's decision must be reviewed in the same manner we review administrative decisions under 41783F. And that statute gives 5 reasons and 5 reasons only that the administrative decision can be overturned. That it was founded on or contained error of law, that it was unsupported by any evidence, that it was materially affected by unlawful procedure, that it was based on a constitutional violation, or that it was arbitrary or capricious. It's a very limited standard. It's a standard this Court is generally familiar with from other administrative review proceedings, because it's a standard that says to the Court, even if sitting as the administrative body, the Court might have chosen to make a different decision, the Court doesn't get to substitute its judgment for that of the governing board as the deciding body. It only gets to overrule them in these limited circumstances. Mr. McKee's made a host of arguments trying to fit into one of these limited statutory grounds, but none of them actually satisfies the statutory requirement.
What's
Judge Portley?
Your best argument with respect to why Judge McClellan erred? Regardless of what Mr. McKee may have argued, what you're saying is that if when the board looked at the record as they modified it, they came to a different conclusion, and so Judge McClellan was required, in the absence of one of these 5 factors, to give the board's decision deference.
And really, the clearest example, we don't have a lot of explanation from Judge McClellan of why he reached his decision. We now have a list in which he says, I really did find all of these things, but still without an explanation. But the most glaring example of failure to apply the statute is really the failure to apply the standard of 41783F2, which has to do with the amount of evidentiary support that the governing board's decision has. And that statute says you can only overturn it if it's unsupported by any evidence. And here, the governing board's decision is based on uncontroverted evidence on findings they didn't even have to modify. They based their decision on the fact that Mr. McKee had a student in his class who he knew couldn't swim, that he let the student get in the pool under circumstances where he acknowledged he couldn't maintain constant vigilance of him. And they found that to be defective professional judgment. That's the basis on which they terminated him. The difference between the way they looked at the case and the way the hearing officer looked at the case is really about that conclusion. The hearing officer found all of those same facts. The hearing officer just focused on whether there was enough time once the student started to get in trouble for Mr. McKee to have saved him. In the district's analysis, the key point was much earlier. It was the point at which Mr. McKee made the decision in the exercise of his professional judgment to let the student get in the pool in circumstances where he couldn't observe him. And there was testimony at the hearing from other teachers that if they had a student who couldn't swim, they wouldn't let the student get in the pool unless they could watch him all the time. If they couldn't watch him all the time, they'd pull him out of the pool. That's essentially what this case is about.
Your argument to us is essentially that the board gets to draw the conclusions from the facts.
Provided that they're reasonable conclusions. When we're talking about regular administrative proceedings, we call it the substantial evidence standard, which is one of those really misnamed standards, since it really just means if there's more than one reasonable decision, and the agency's decision was one of the possible reasonable decisions, they get to make it, and the review process has to respect that.
How's that different from here?
Well, that's what should have happened. Because it was a reasonable decision from the evidence, right, it should have been affirmed. It doesn't get to get second-guessed in the appellate process.
I thought for a moment you were arguing a distinction between the ordinary administrative review and this one.
No, it's effectively the same standard. The statute just makes very clear what that standard is. You can only overturn the conclusion if it's just unsupported by any evidence, not simply because you disagree with the conclusion that was reached from that evidence.
Am I correct in understanding you that when you reference the statute, you're referencing 15543B's referral to 41783?
Yes, and it's 783F. F is where the standard of review appears.
The five items.
I feel as though I should draw a diagram. It's sort of a complicated statutory path.
I mean, could you address whether the board had all of the evidence that the hearing officer had? Seems to be some confusion as to whether everything that was presented to the hearing officer was in fact presented to the board.
Everything presented to the hearing officer was made available to the board. Did they all sit together in a room and read it during an open meeting where everyone watched them sit and read it? No. But they had materials, they had briefing from either side to point them to the parts of the record that both the administration and the teacher were asking them to look at. And there's absolutely no evidence in the record that they didn't have the entire record available to them. There are documents in the record that say, it's in this conference room, go look at it to the extent you want to see anything, and then each side, just like we did in this case, picked and chose the specific parts of the record that it wanted to call the board's particular attention to.
I thought there was some suggestion that they didn't have the transcript from the second and third day of the hearing.
The evidence that Mr. McKee pointed to in front of Judge McClellan was that there was a moment in the public meeting, which is where they're actually doing their deliberation, after they've had the opportunity to look at the briefs, to look at the record, where they had some copies on the bench with them. They sit on a dais that's not unlike this one. And those copies aren't big enough to be the whole record. And they were told that those were to be gathered back up. And that's essentially the evidence that Mr. McKee has pointed to suggest that they didn't have the whole record, because the papers that were on the desk next to them weren't enough. That's what the evidence is. And the problem is that doesn't actually establish that they didn't have the entire record to review. And here you have the written indication that they were told this is where the record is to the extent you want to go look at anything. You have the hundreds of pages of briefings submitted by both parties. You have the transcript of the 3-hour hearing that both parties got to speak at which they could tell the governing board, please go look at this, please go look at that. There's no evidence that the board was denied access to something that it needed to look at in order to adequately review the hearing officer's findings. And yet again, we come back to, it's important to recognize that the governing board's decision isn't really based on different facts than the hearing officer. The only modifications the governing board made to the hearing officer's factual findings were the hearing officer had some very precise language about times. It was only a minute, it was only 2 minutes, because the hearing officer was focused on whether there was enough time to pull the kid out of the pool once he started to get in trouble. The governing board apparently thought that those times weren't quite exact. If you look at their factual changes in the fact findings, all they do is make those slightly less precise. And then they just reach different conclusions, which McKee has suggested, both in this court and below, that something that can be fit into the due process category is an automatic pass to reversal. And that's not what the statute says. The statute says in 41783F4 that decisions are overturned when they're based on violation of a constitutional provision. So even assuming, let's assume, and there's no evidence of this in the record, but let's assume that half of the transcript of day 2 was missing from their copy. That half of the board's copy. Those transcript pages would have to matter somehow. They would have to somehow form the basis of the governing board's decision, both to be a denial of due process itself, because due process isn't just based on procedural irregularity, but procedural irregularities that go to constitutional minima of fairness. And because the statute tells us the decision can be overturned if it's based on a constitutional violation. And here we have that continued failure to connect the dots. There were a couple of statutes missing from the copy of the statutes attached to the statement of charges. Well, that's a statutory violation, technically, but it only fits under the statute as a ground for reversal if it materially affected the proceedings. You can imagine a circumstance where it would be material, someone didn't realize what an appeal deadline was or something because they were missing a statute, but there's just no evidence of that here. And that was essentially McKee's argument below. List lots and lots of things that either are procedural violations or could be construed to be procedural violations, but that's not what the statute would have required him to do in order to overturn the governing board's decision.
Although when you have lots and lots, if there were lots and lots, at some point it becomes unfair.
But there weren't actually lots and lots. Of all of the lots and lots that he alleged, there were 2 things that actually happened. One is that there were some pages missing from the photocopy of the statutes. And the other is that a governing board member went and looked at the pool and confirmed the undisputed fact that you can't see the bottom of the deep end when you sit 10 feet away.
What were the circumstances leading to that? Did the board member just on his own go? Was he invited to go?
It's not in the record why he decided to go. He said he went and looked. He said he saw that, in fact, and that's the way he says it. I went and looked myself, and it's true that you can't see the bottom of the pool. Which
was already the evidence?
Everybody knew you couldn't see the bottom of the pool. All those of us who've seen a swimming pool know that if you sit 10 feet away, you're not going to be able to see the surface of the bottom of the pool, particularly when there are a couple dozen kids in it. It wasn't either a particularly material fact or a disputed one.
When was that disclosed that the board member had?
He talked about it during the public hearing in which the decision was made. It was one of the comments that he made. For the governing board, it's sort of like having not just the oral argument, but your conference televised, because they have open meeting law requirements. So they can't talk about the case except in an open meeting. And that's what you have that transcript of. That's that 3-hour meeting, is a combination of oral argument and their deliberation. And in the course of their deliberation, in explaining his decision making, he says, among a bunch of other things, I went and looked at the pool, and what the witnesses said is true. You can't see the bottom.
At that point, does Mr. McKee have an opportunity to say, I'd like to take everyone to see the pool, or I'd like to have have my attorney present or to make some different demonstration? Was anything like that raised?
I don't believe he asked for such an opportunity, and I can't therefore say what would have happened, but it seems like the decision wasn't done at that point, certainly.
But he doesn't have a lot of notice, obviously, at that point.
No, he didn't get advance notice. It was during a hearing at which his counsel was present, at which he was represented, that one of the board members said, I went and looked at the pool, and it's true that you can't see the bottom. But the issue, of course, was whether a student should have been permitted in the pool in the exercise of professional judgment where the teacher knew the student couldn't swim and also knew that he couldn't maintain constant vigilance of him. Not being able to maintain constant vigilance wasn't just because you can't see the bottom of the deep end. The bottom of the deep end is about seeing the kid once he's in trouble. If you're watching him, you want to see him on the surface of the deep end, right? You want to see him still up in the water. And the reality is there were a whole bunch of kids in the pool. And McKee was talking to the other teacher, going and looking for equipment, doing the kinds of things that you would expect a teacher to be doing when he has a bunch of students in the pool who can swim. He just let a student in the pool who couldn't swim. And the evidence, the testimony of 2 other teachers and 1 principal, all of them academic professionals, was that's not the exercise of good professional judgment. If I had a student who couldn't swim, I would only let them in the pool when I could watch them like a hawk.
When you say couldn't swim, there is a difference. That did the student represent that he could not swim, or that he just had some limited?
Everybody knew he couldn't swim. This was toward the end of a 3-week swimming unit, and he wanted to learn to swim. So he told the teacher he wanted to learn to swim, and the teacher had been finding ways for him to practice, giving him a kickboard, teaching him to dog paddle in circumstances where he could watch him in earlier days. So there's no dispute that the student couldn't swim. Everybody agrees the student couldn't swim, and the student had disclosed it to the teacher. Mr. McKee didn't disclose it to the other teacher who was at the swimming pool, Mr. Allen. What happens is Mr. McKee's class and Mr. Allen's class have a time overlap. It's McKee first, and then Allen's class comes in, and then McKee's class leaves. During the overlap, they do free swim, because you get too many kids really to do anything else. So it's during that time period that this incident happened. He let the student who couldn't swim stay in the pool, didn't tell Alan to help watch him that he had a student who couldn't swim, and didn't watch him constantly.
What's your explanation for the delays in providing discovery or disclosure in connection with the public records request, or were they made simultaneously with requests in the underlying proceeding? Or?
Sure. At the point that this all happens, there are several things going on at once. The statutory process is district administration prepares a statement of charges, takes it to the governing board votes on it. It's sort of a bad analogy, but think of it like an indictment. If the things in here are true, it's cause to go forward with termination. Teacher can either accept the discipline without challenging it, or can say, no, I'd like a hearing. Requests a hearing, and then there's time to conduct the hearing. And it's a pretty fast statutory time to conduct the hearing. The hearing can be either done by the governing board or by a hearing officer. Here, the governing board delegated it to a hearing officer. And then that hearing officer handles the procedural stuff. Motions in limine, disclosure, witness list, and you've got a lot of that in your record. You have all of the motion practice, you have the witness disclosures. So there's that whole practice available. What happens here is that after the adoption of the statement of charges, Mr. McKee sends a public records request that requests a whole slew of documents. The testimony in the other action in front of Judge Potts is that the district starts gathering the documents but hasn't produced any of them yet. And then Mr. McKee files a lawsuit with several grounds. He files a lot of the same challenges to the hearing process that are before you today. This is inadequacy of classroom performance, so I get 60 days. There are due process issues with the way the statute works, et cetera, et cetera. So he tries to block the hearing entirely. And he also makes an open meeting law and a public records argument based on, and the public records argument is based on the fact that it's a little less than 2 weeks later and he doesn't have any documents yet. Fast forward, we're now 3 years later, and That's the only claim that survived in Judge Potts's action, and she held a 2-day trial and determined that the district had waited too long, essentially, to produce the records. There was quite a bit of argument in front of her, and you see this reflected in her final decision, which I believe is the one that you got the last minute entry of hers, I believe, from Mr. McKee, who has made a res judicata argument based on it. And what she says in that final minute entry, there's a lot of discussion in front of her about whether the statutory compliance with the public records law, which is promptness, has to do with what your extrinsic need for the documents are. And the district said, look, you can't consider the timing of the hearing. Our obligations under the public records law are under the public records law. And it's either prompt or it's not under the public records law. It doesn't matter if he needed them for a hearing 3 days later or not. And so she pretty carefully disclaims in that last ruling, contrary to some things she'd earlier said, that this was about whether he needed the documents for the hearing. Which from our perspective means it's not res judicata as to a due process argument regarding access to information for the hearing. And in fact, the rest of the records you have before you, his witness and exhibit lists, the hearing transcript reflects that he had ample opportunity to participate in the hearing. Moreover, since this is not a case about disputed facts, everybody agrees about the very limited facts. It's just they disagree about how to interpret them. Mr. McKee says they're not cause for termination, and the governing board in the exercise of its judgment has said they are cause for termination. He hasn't even attempted to draw a line between some document it took him longer to get than he wanted in the public records context and how it stopped him from challenging that legal conclusion in the hearing. And that's what he'd have to do here.
Does the board owe, I realize you're about to
Oh, it's
reserve your
fine.
time, but does the board owe a teacher such as Mr. McKee a written decision rather than just an oral decision?
That part of the Judicial Review of Administrative Decisions Act of 41783 wasn't incorporated. They don't have a written decision requirement. Due process says you have to know at least enough about what's going on to be able to go through the process. But the reality here is they did have a written decision. It's just they're a public body. So they make the decision in December. They have a vote. They have this 3-hour hearing and deliberation. And in that hearing transcript, you see them voting. They have this chart of the findings, and they're voting to change this one, and they're voting to change this one and reach a different conclusion. That all has to be written down by somebody. And you can't really write it down in advance because they're a public body and they have to make a decision in an open meeting and you don't know what they're going to do. So bodies like that have written minutes that take time to get out. And that's exactly what happens here. All of those decisions that they make in December in a public hearing that Mr. McKee's representatives attended, so he knew about, get turned into written minutes, and the written minutes get approved by the public body in January at its next meeting, and that's their written decision.
So is that what's appealable rather than the oral decision?
And that's effectively what the trial court ruled when it set the deadline to appeal from the minutes rather than from the decision. They're really the same decision. The January minutes are just the written reflection of the December decision. They're the same.
It would be a veracity exception under any different analysis.
It's kind of like when this court issues an order and says decision to opinion to follow. It just, there's this time delay, and it's the weirdness of being a public body that really generates the time delay. Due process concerns about lack of written decisions are when you don't get anything, not when we have a meeting and it takes us a month to adopt the minutes, but you still got the minutes. I have about 3.5 minutes I'd like to save, if I may.
Thank you.
Thank you.
Counsel.
Good morning, may it please the court. My name is Kevin Kelble. I represent Timothy McKee. What I heard Mr. Marcy just say, that her best argument was that the board had the right to terminate Mr. McKee for lack of professional judgment. That's the same argument she made in her closing in front of Judge McLennan, and he asked her, where's that in the statement of charges? And if you look at the statement of charges, that's not in there. The statement of charges says we're going to terminate you because you violated district policy and you didn't adequately supervise your classroom. Ultimately, there was no district policy they could identify that he had violated, and if supervising your classroom is the issue, then that plainly falls under 15539C, and he was entitled to a 60-day period and an improvement plan before they could even proceed with the hearing. And that was one of the issues we raised with Judge McClendon, and he agreed that it's classroom performance. And Wheeler, which is the versus Yuma, which is the only authority on the issue, specifically says that.
But there was no question here that Mr. McKee was aware of the reason that this was all based on a student drowning in his class.
Well, no, they said that was not the reason. They said the drowning had nothing to do with it. It was that he had just violated district policy. And when we asked for the policy, they couldn't produce one. And ultimately, they said, well, it's just common sense that you be supervising the pool. Well, prior to the board adopting the charges, he had notified them that under the intergovernmental agreement with the city, they were supposed to have provided 3 lifeguards according to the county regulations. They were supposed to provide the supervision. And 3 days later, they decided to terminate his employment for his alleged failure to supervise the pool. And a key thing here is they keep talking about Mr. McKee couldn't see the bottom of the deep end from where he was sitting. There were 2 teachers at the pool, and the undisputed evidence was they had made an agreement because there were so many kids in the pool. Mr. McKee was going to supervise the shallow end of the pool, and Mr. Allen was the teacher supervising the deep end of the pool. Mr. Allen was sitting right next to Mr. McKee. He couldn't see the bottom of the deep end of the pool either. No discipline for Mr. Allen. Mr. McKee gets terminated. That's disparate treatment. That's an arbitrary and capricious result, because if they're both doing exactly the same thing, they should both be treated exactly the same way, and that didn't happen.
And isn't the board's argument that Mr. McKee was the person most responsible for supervising? It's his student, and he's the one who has to make the decision about whether to let him in the pool in the first place. Isn't
Correct.
That different
And I heard Mr. Marcy say he was a non-swimmer. That's not what the evidence was. That wasn't even the allegation in the statement of charges. It was he was a beginning swimmer. He chose to be in the pool, and actually the statement of charges says he could swim a few strokes in dog paddle. So this thing that it was a non-swimmer. He was in the shallow end of the pool 2 minutes before he drowned. Nobody knows why he chose to go to the deep end, but in those 2 minutes, one of the teachers certainly should have seen him, and if neither one of them did, why is Mr. McKee the only one being terminated? And the whole thing, in that respect, doesn't make any sense. She talked about, or I think maybe Judge Gemmell said that the board drew different conclusions from the facts. That's also not what happened. What happened was the board voted to fire him, and then they said, now let's go back and look at the facts to change them to support that conclusion. That's ass backwards. They should be looking at the facts, then making their decision. And she's shifting the burden to Mr. McKee to prove they have the record. That's not his burden. There's no evidence in the record that they ever saw the record. They said, well, it was available, and they might have gone and looked at it before that day. Well, if they went and looked at it before that day and reached conclusions on the facts prior to deciding to fire him, that's a due process and an open meeting law violation.
But assuming they didn't actually already make a decision ahead of time, there's nothing, presumably, that kept your client from presenting whatever evidence he wanted to present, from making a notebook or whatever that could be given to the board, is there?
We did not know that any information had been given to the board. That was done in an ex parte communication. I also heard Mr. Marcy said, with respect to who invited Mr. McCord to the pool, there was no evidence. There was a cover letter attached to the binders that were given to the board that invited them to go to the pool, all the board members, and instructed them to make arrangements with the superintendent's secretary, Ms. McClarty, to do that. That was another ex parte communication with the board, of which we were not aware. Standing, making the closing argument to the board is when Mr. McCord told me, I went out to the pool, and I said, that's a due process violation. I have not had opportunity to address that. He says, well, your opportunity is right now. That's in the transcript. That's what happened.
And what's your response to the argument that there's really no dispute about whether someone could see the deep end from where they were sitting?
Well, there was more to what he said he observed than that. He said he walked all around the pool and found the best spot to look, and he said his decision was based on what he saw, and we don't know what he saw. And the other explanation is Stivers versus Pierce. It says one member of the board is biased and the whole panel is tainted. It's just not fair to Mr. McKee that after the close of the evidence, the tribunals have been invited to go out and do their own survey of the pool. I mean, that's just not. In fact, they were confronted with that by Judge McClendon, and he said, would you have a problem with me right now going out to the pool and checking it out? And they said, no, that'd be fine. And he's pausing, goes, really? Because that's a violation of the Code of Judicial Ethics. I mean, it's just not proper for the board members to be doing
But
that.
that's a different consideration, an ethical violation as opposed to a factual predicate. Now, he's not supposed to do that, but in the change canons, he could.
Correct. But when he does it, even though it's
He's
just...
got to then articulate what he saw so people can.
Correct. And
understand.
I keep hearing them say, well, there was substantial evidence to support the decision. But what was it? They've never identified it. Because there was no written decision. And now they're saying, well, the minutes were the written decision. That's not the argument they made to Judge McClellan. We had a long hearing where they kept saying December 6th was the decision date, that triggered it. And he says, well, then the minutes aren't part of the record because that comes after the appeal is filed. And they said, well, you can look at it. And the conclusion was, they argued the transcript of December 6th was the written decision. That was their argument. And they prevailed upon that. And he says, well, I'm going to look at the transcript of December 6th, and I will only look at the minutes to the extent they're consistent with December 6th. You can't change the decision later on, which is what they're trying to do.
Let's assume we agree with you that there was a due process problem with this one board member going out to the school, and maybe also with the invitation being sent by the administration for the board members to go out to the pool and look at it. What's the remedy?
Well, the remedy is that you have to overturn the decision, which is what Judge McClellan did. If they had complied with all the due process requirements and all the statutory requirements, McKee would still have his job.
Does the board get to have another hearing?
I don't believe so. I believe that the statutory deadline is passed. If they want to start over, they could. But I don't believe that if the remedy, if the only relief McKee gets is the board gets a do-over, that's no relief at all. If they don't comply with due process, I mean, that in and of itself is an injury that's not curable by de novo review. And if they violated the statute, I mean, the deadlines are there to protect the teacher. If they don't meet the deadlines, I mean, it's like any other statutory deadline. You miss the deadline, you're out of luck. If we don't hit the 180-day notice of claim deadline, we don't get a do-over. If they don't hit the 25-day statutory deadline for having a hearing, why should they get a do-over? They're the state. They're in control. It's their responsibility to protect Mr. McKee's constitutional due process rights.
Is there anything about the discovery, other than the board member going to the pool, what in your view is constituted a due process violation that prejudiced your client in terms of getting discovery late?
There's a whole list of them in Judge McClellan's decision, and there's a late discovery. We had asked before, when the original request was not necessarily a public records request, part of it, what we requested was just information about the case. And we requested that information in order to make a determination as to whether we wanted to go forward with the hearing, because, most often the case is when you're advising a teacher is you just need to negotiate a resignation and get out of here because you're going to get clobbered. We didn't get any information prior to the deadline to request the hearing. And what was in the statement of charges, I mean, was nothing. There's like 10 exhibits, and they don't support the charges, which is what the hearing officer ultimately found. So we were looking for the information to decide whether to request a hearing. The deadline to request the hearing came, so we requested it. We wrote, on the same day, we wrote to them and said, we made this request for information, where is it? No response. So we filed the lawsuit, including the public records request. That week later, we get a response, still no records. And what Judge Potts found was, and this is interesting because they put this in their reply brief, because I just heard them say she was relying on the fact that he needed them for the due process hearing, but here's what's in the reply brief. The Superior Court stated that it has not considered or relied upon McKee's need for the records in finding that the district did not act promptly. So that wasn't the issue for Judge Potts to determine promptly. What she said was the investigative file was at all times in the Human Resources Director's office in her credenza. She started gathering that information on the day he made the request, August 24th, and it took him 23 days to hand it over. And it was just, it's a couple hundred pages. It's not even 200 pages.
What I'm hearing you say, the initial reason is just for us to decide whether to contest it.
Correct.
Presumably, you would have contested it, and Mr. McKee would have contested it, knowing what he knows, even after receiving everything. Is there something else that he would have done differently, or did the late disclosure, how did the late disclosure affect his ability to?
What we found that the late disclosure continued until the day, actually 5 o'clock on October 3rd, we were getting interview notes of witnesses that for a hearing starting at 9 o'clock on the 4th. We could have interviewed those witnesses. There was no opportunity to do that. We wanted the names of the students who had witnessed what went on. Never got it. Till even now, we don't have those names. We could have gone and interviewed those students and found out what was going on.
But what type of evidence do you think would have been developed? What's your best argument for how you were prejudiced? What witnesses would
there might have been a witness who could have told us what happened. No, because the evidence they have is they don't know why that student went into the deep end. There could have been a witness who could tell. And one of the crazy arguments they've made now is that McKee wasn't standing in the best place to supervise the pool. The student who rescued the drowning student was in the best place. The student who saw was standing on the diving board. So they're suggesting now that McKee should have been standing on the diving board. That would have been the best observation point. I mean, it's just crazy. And there were 40 students there. Somebody might have seen something that would explain what really happened.
But did you make a request to interview students, or is that what you're saying?
We couldn't interview them. We didn't know we still don't know who they are. Jewel says we get to have access to witnesses and evidence. We didn't. We didn't get it. And
Sorry to interrupt. Was there any testimony from students at the hearing about a student who had watched him drown?
We had my recollection is the student who rescued him testified because we knew who he was. And we went round and round with this in front of Judge Potts on this student contact information. The district created the log on the day of the drowning and gave it to the police department. That was the conclusion. In fact, they stipulated to that in their pretrial statement. And they just wouldn't give it to us. I mean, the list existed with the contact information. Wouldn't give it to us. And to say, and in fact, they denied it existed. They said if it does exist, we've never seen it. And then when they get to trial, they said, well, the reason we didn't turn that list over is because you requested the names of all the students. And the student who drowned, his name wasn't on the list, so it wasn't responsive to your request. I mean, it was just absurd.
And you didn't know that the police had that list?
The police report said that the log had been given to that the district had given the log to the police department. We ultimately did a public records request for the police, but their policy is they don't release the names of minors. So they wouldn't give us, we got a redacted list from the police department long after the hearing was over. The biggest due process violation here is the lack of impartiality of the board, which stems from the fact that it's the board's lawyer who's appearing before the board in this hearing. On August 20th, the decision is made to terminate McKee. That's the statutory process. If he doesn't request a hearing, that's the termination decision. And on that day, the board's in executive session with its counsel and the charging party, the superintendent, and the director of human resources, and they're all talking about what we're going to do with the statement of charges. And then they come out, and the president introduces the lawyer as the board's lawyer. Then we get to the hearing, and the board's lawyer is now representing just the superintendent, and she's prosecuting the case, and the board is sitting in judgment.
The board gets separate counsel at that point, though.
Nope.
Do they not?
No. The board doesn't have separate counsel until December 6th, the last day of the hearing. And the problem with that is twofold. And of course, by the time the hearing starts, McKee has sued the district. So the bias is twofold. There's the bias in favor of its own lawyer, and then there's the bias against McKee's counsel, who's not only suing them, but he's filed a notice of claim asking for $300,000 by then. In fact, that happens before they even adopt the statement of charges. So the board's got a lot of good reasons for not wanting to rule in favor of McKee.
What is the board supposed to do? I mean, that's something that was initiated by Mr. McKee, presumably the suing the district. Is that
just get different counsel?
But he can force them to get different counsel just by filing a lawsuit? Where should they have had different counsel, I guess is what I'm asking.
Well, they could have had different counsel defending the lawsuit. They could have had different counsel in the hearing to eliminate that factor. But of course, you can't eliminate the fact that he's suing them, and the question is, he's got a right to sue them. I mean, the problem with this, and this I've been making this pitch for a long time. The problem with the statutory process on its face is it's unconstitutional because the board makes the original decision to fire him on August 20th, and his appeal then is to the board to say that was a wrong decision. I mean, R.L. Augustine addresses that in the procurement statute and says where the reviewing body is the same body that made the initial decision, that's no review at all. That's like appealing Judge McLennan, and we get here and Judge McLennan's sitting on the dais. That's not that doesn't comply with due process. The other part of the bias.
Before you
Sure.
leave this point, if we could, I want to try to fully understand it. I'm not quite sure your point about the board has a bias against you or against Mr. McKee's. I mean, is that the board's fault? I mean, how do you measure it or demonstrate it? How do we know?
I'm just relying on what's in State versus Salazar, which says that when the tribunal, when the lawyer appearing before the tribunal or before the judge is suing the judge, that's a bias. That's just what the case law says, and they don't set out a test that you have to prove the bias. It's just an appearance of impropriety. Now the other.
I'm trying to recall, but I think, and of course this is in the realm of judicial ethics, which is, as Judge Portley already said earlier in a different context, is different. But I think we have judicial ethics opinions that say that a litigant can't cause a judge to have to recuse simply by suing them. So I'm having trouble following. I'm more easily following your argument that there might be a bias issue of some sort in regard to the board's lawyer and the district's lawyer and the same lawyer having advised the board.
And I understand the concern.
I'm having trouble with I'm having more trouble with your argument that just because Mr. McKee, through the same lawyer, has sued the board, that somehow it's the board's fault now that Mr. McKee has the same lawyer representing him before the board.
Correct, and I understand the concern. You don't want litigants to be able to, strike judges by suing them, but there's got to be a reason to do it. And in this case, the allegations were that the process that the board was embarking on was unconstitutional, that they were violating his due process. They had to comply to the statutory deadlines, and they haven't given them adequate disclosure before the hearing. So it was tied to the hearing. And we were just looking for declaratory relief. They said we were trying to stop the hearing, that we were trying to delay the start of the hearing. What we were trying to get in that action was a fair process. We wanted the names of the witnesses. We wanted the documents we needed for the hearing. We wanted all that to happen before we went forward. We would raise the concern about the board's counsel now appearing, and it was the board's counsel in the lawsuit in front of Judge Potts, now Judge Mullins, that was also going to be the prosecutor in the other case. I mean, it just, she sat in with them and advised she advised the board about what to do with this statement of charges. And then they come out and she's the prosecutor. If I had met with this panel before they filed a notice of appeal to discuss this case, you can bet that they would have an objection to that. In fact, I called Judge McLennan, this is in the record, I called Judge McLennan's JA because they filed what they titled a renewed motion to dismiss. And I called the JA, I said, is the judge treating that as a motion for reconsideration or a new motion, and should I wait to file a response if it's a motion to reconsider? They accused me and the judge of having ex parte communications just based on my calling the JA for a scheduling matter. So surely, the prosecutor meeting with the judge before this and advising them about adopting the charges has to be a due process violation. There's just no question about it.
But you're saying that would apply virtually every time a school board takes action against a teacher. Isn't this just kind of the statutory framework we're working under?
No, they can get it. They wait on December 6th. They brought in a different lawyer to advise the board. See, when they hire a lawyer who does the investigation, drafts the statement of charges, and is representing the superintendent as the charging party presenting the charges, what they should have done then was bring in the second lawyer to advise the board. That on August 20th, that executive session should not have included the lawyer who was going to act as the prosecutor. The second lawyer should have come in then. They should have separated the roles when the termination process started, not in the middle of the termination process.
Would it have been all right with you if, in your, I don't mean with you personally on some personal level, but I mean, would it have been all right in your view of the due process aspects if the board had kept the lawyer who had advised it as the board's lawyer and hired immediately upon the filing of the charges a new lawyer to be the, I'll put it in quotes, the prosecutor?
Probably not, because of the fact that the lawyer who had done the investigation, had been the board's lawyer all the time, had been in the executive session with the charging party.
Of course, you know, in the judicial system, we're used to having real sharp lines dividing functions. In the administrative law and agency and school district world, sometimes these executive branch entities have more than one function.
And that's
harder to draw the lines.
That's true, but there was no attempt to draw any lines in this matter.
But wasn't there an attempt before a decision is reached by the board? At that point, they are advised by separate counsel?
Well, on December 6th, at that hearing, there was Denise Bain was sitting on the dais with the board. That was, and she, if you read the transcript, she had no idea what the board had in front of it. Her role was so limited at that point. They never went, as my memory's not as good as it once was, so I don't recall. I think there was an executive session that they went into, but it wasn't to talk about or deliberate, because that was all in public. So during the deliberations, she didn't give any legal advice. So I don't know what, I mean, that was just, and in
she's
fact,
presumably there. The lawyer doesn't have to inject herself. Presumably, if they had questions, they had separate counsel to ask.
What she told Judge McClellan was that at all times throughout the process, both she and Mary Ellen Simonson were lawyers for the district, and that for the purposes of the termination process, they created what they call an artificial bifurcation, so that she's representing, Denise was representing, Ms. Bain was representing one aspect of the district, and Mary Ellen Simonson was representing a different aspect of the district. And as soon as the decisions were made, their interests realigned again, and they could both go on representing the district as a whole. I mean, it's all one entity. In fact, that's why I filed my request for judicial notice, because in order to sustain the due process, say there was no violation of due process, they had to make the argument that they were separate entities for the purposes of the hearing. So they said, okay, if you're separate entities, then we're alleging a conspiracy. That's part of our federal suit. They go to the Judge Snow and say, oh, there can't possibly be a conspiracy. That requires separate entities, and we're all the same entity. They can't have it both ways.
Can you remind me if we have any specific cases on council and school districts and board hearings?
The only case that addresses the multi-functions is Rouse, and Rouse says they can be the investigator and they can be the adjudicator. It doesn't say they can be the investigator, the adjudicator, the prosecutor, and the charging party. It's much narrower. What's permissible in Rouse is much narrower than what went on here. I have 49 seconds left, and just want, with respect to the stay, we have no objection to staying in the judgment.
Okay. Thank you.
Before you go,
Okay.
please. And I should know the answer to this, and I apologize for not knowing it, but let me just ask you. Would you anticipate that if you had gotten discovery sooner or disclosure sooner and gotten the names of the other students, that you would have sent an investigator or perhaps someone from your office to interview every one of those students?
There were witness statements that were provided to the police department that we got redacted as well. So there were other witness statements that we could.
You had some notion, at least based on that, what they might say.
But
when you say redacted, is it just the names?
The names were redacted. So and we knew that there was conflicting stories about what happened. Some of the witnesses had said that the student who drowned had actually been hanging from the diving board before he drowned. And if that were true, then Mr. Allen's got some explaining to do, because that was improper behavior. He should have noticed that before the drowning. We don't know who that witness was.
Was there any suggestion that another student had pushed pushed him underwater?
There was not.
And well, I was going to say, is this in the record, or is this from your post-hearing discovery that's been going on?
So the witness statements that says, that was actually raised at the hearing with Ms. Tanner, that why did you disregard those witness statements? And she said she made a deliberate attempt when she was drafting the charges to exclude certain witness statements.
Was there, I realize the time's out, but I think the presiding judge will let me take one more shot here. Were there witness statements, I gather with the names redacted, that indicated that the young man who died had kind of moved along the edge and was talking to people?
There were some
Was there anything
statements.
that tied together how he got from there to the bottom?
There were some witness statements that said, moments before there's an L-shaped pool, and he was at the corner chatting with some other students. Those students didn't testify. And ultimately, and just so we're clear, ultimately we get all the records unredacted, but not in time. Not in time to prepare for the hearing.
Well, that's, I guess, the question, sorry to go over again, but is there something that you got after the fact that suggests that you would have done some sort of discovery? We
would have interviewed. So you're asking me, what would you have found if you'd investigated? We don't know, because we never had the opportunity to do that. And that's where the deprivation of due process is, because we don't get to do an investigation. We're stuck with what they've allowed us to present. We were stuck with only what they allowed us to see. I mean, that's
what are you hypothesizing a student might have said that would have changed?
Just what Judge Portley suggested. There was horseplay. There was something going on. There was, that there was some other explanation for what happened other than the teachers didn't see it happen. Thank you.
Thank you.
Before I forget, Judge Gemmell, in addition to the Rouse case, you might look at Pavlik and also the federal case of Withrow v. Larkin. Those are the three cases about the permissibility of combining the investigative and adjudicatory functions, so long as you split folks up when you need to split them up.
Even if the lawyer that the board now sees as in front of them as the prosecutor has advised the board many times in the past on all kinds of things?
Indeed.
I mean, I realize there's a separation there, but there's also a long-standing relationship.
And as Judge Catani's question suggested, I think it was Judge Catani's question, it's really built into the statutory scheme. The statutory scheme says the governing board has two roles. One is, at the very end of the investigative process, it decides if there is enough information presented that it would be cause for discipline if it were true. Right. And then they step behind their wall and they come back again after there's evidence and they make the final determination based on the hearing officer's recommendations about what to do. I should note, there has been no notice filed pursuant to the statute. If you're challenging the constitutionality of a statute, you have to tell a whole bunch of people down the street so that they can participate. This isn't one of those cases. We haven't done those notice requirements, just so you know. Talking about students and student statements and prejudice, the question really of how any of this would have affected the proceedings is the key question with which all of Mr. McKee's arguments about process have to be interrogated. And with regard to the students...
Know what we don't know.
Well, here's what we do know. There's a statement of charges, and the statement of charges, by the way, does talk about unprofessionalism and does talk about the need to exercise supervision. That's pages 17, 33, and 34 in the district's record on review, which is the first huge chunk of our appendices. Attached to that statement of charges is the police report with all of the police's witness statements, where all of the students describe what happened.
With their names?
Well, with their names, they're redacted. It's my understanding that the hearing officer permitted access to an unredacted list of names during the lead up to the hearing. But the statute gives you 20 days to hold a hearing. It's never going to be a long period of time, even if you have the list of names. But it's important to remember, the governing board's decision is based on not professional judgment to put the student who can't swim, who's a beginning swimmer, he can only swim a few strokes, in the pool. to change that judgment, you would have had to have a student who said, no, actually, he can swim really well. You would have had to have some fundamental change in the facts.
What if the drowning occurred because another student held someone under the water that was really, that would have happened even if the student had been a better swimmer? Wouldn't that be relevant to the hearing?
And if that were what happened, presumably there would be a scintilla of evidence of something like that somewhere, and the police interviewed more than 24 students and found nothing. No indication of that at all. And we have a statutory process that says you get a pretty abbreviated hearing. The court may recall one of Mr. McKee's other procedural arguments is that we in fact held the hearing too late. But he simultaneously would like to tell the panel he needed more time to interview dozens of students and didn't get their names under a confidentiality agreement until too close before the hearing. The fundamental question here is really twofold. Is the board's decision unsupported by any evidence? Clearly it's not. And is there any procedural defect that really made a difference here, to the extent there are any procedural defects at all? I've exceeded my time. I appreciate the court's patience.
Questions for her? Apparently not. Thank you very much.
Thank you, Your Honor.
We appreciate the argument of counsel. Fascinating special action. You both helped us. We've got a lot of things to chew on. We will take this matter under advisement and issue a written ruling in due course. Until then, we stand adjourned. Thank you.
Thank you. Yeah.